that mean?
Probable cause means police must have clear facts or evidence to believe you're involved in criminal activity. In other words, an officer's hunch without evidence of illegal activity is not enough.
I believe that there is a suspected bombing fugitive in your house. It is illegal to harbor a fugitive. Let me inside so I can search for the criminal.
Can I see that you have a search warrant? I have a legal right to know if you do.
I do not have one, but I need to come in anyway. I believe that you, Dole Remap, and your daughter are sheltering a criminal.
My lawyer told me not to let you in unless you have a warrant. Otherwise, it is not legal to search my house.
We are breaking into your home. This is the warrant right here.
That is not a real search warrant. You are not allowed in my home without one. You are violating my Fourth Amendment right that protects me from unreasonable searches and seizures. I have a right to privacy. If you deny my rights, I will fight for them in court.
We are going to cuff you because you are possibly dangerous. We searched your basement and found a chest of obscene material. It is illegal to possess pornography in the state of Ohio.
That is the previous homeowner's trunk. I had no idea what was in there.
Likely story. Tell it to the judge. You are going downtown.
Ohio, 1961 is significant for interpreting the Fourth Amendment correctly. Even though police found obscene material in my house, it could not be used as evidence because it was obtained by illegal means. My case gives us peace of mind by protecting us from unreasonable searches and seizures. The Supreme Court used the very important exclusionary rule, which forbids evidence procured illegally from being used in court, to support their 6-3 decision. The police should have obtained a search warrant before commencing an actual search. People should be able to feel free to ask the police to provide a legitimate search warrant before allowing them to invade their privacy. My case set an example for the proper upholding of individual rights.
To it, shall we? The petitioner, Charles Katz, was charged with conducting illegal gambling operations across state lines in violation of federal law. In order to collect evidence against Katz, federal agents placed a warrantless wiretap on the public phone booth that he used to conduct these operations. The agents listened only to Katz's conversations, and only to the parts of his conversations dealing with illegal gambling transactions.
Katz versus United States, the Supreme Court overturned the decision in Olmstead versus United States and my conviction along with it. Justice Potter Stewart argued that the Fourth Amendment protects people, not places. It protects an individual's right even in a place accessible to the public, such as the telephone booth on a street corner. Justice Stewart wrote, "The government's activities in electronically listening to and recording my words violated the privacy upon which he justifiably relied while using the telephone booth and thus constituted a search and seizure within the meaning of the Fourth Amendment."
Well, I am glad, Mr. Katz, that you won the case. The Katz case expanded the scope of Fourth Amendment rights to include protection against certain kinds of electronic invasions of an individual's privacy. Since the Katz decision, the Fourth Amendment has been a means to protect individual privacy in places open to the
The year was 1984. You're allowed to smoke
in school in designated areas. While most girls were teasing their hair in the bathroom, Tracy Lois Oden was smoking cigs instead. Later that day, the school caught her and searched her purse. What they found were cigs, rolling paper, marijuana, and proof of drug sale.
Cannot be charged or prosecuted or convicted for the same crime twice.
In 1961, he was accused of burglarizing a pool hall. He firmly denied the charges against him, but since he was poor and couldn't afford a lawyer, Gideon had no choice to defend himself. This eventually led to his conviction. Feeling he was robbed of his 14th Amendment rights, Gideon appealed. Feeling he was robbed of his 14th Amendment rights, Gideon appealed, and the Supreme Court ruled unanimously in March of 1963 he was not given a fair trial. He was retried and acquitted 5 months later on August 5th.
The case of Hamdi versus Rumsfeld was an issue of whether detainees who were captured in Afghanistan in a time of war should be entitled to an appearance in court. The military attempted to work around this by calling these detainees combatants of war. In the case of Hamdi, however, he was an American citizen who was born in Louisiana and moved to Afghanistan. His father fought and earned him a right to trial, citing that it was unconstitutional and violated the 5th and 14th Amendment. This set a future precedent for detainees who were American citizens and allowed them a right to a trial and representation in court.
The major issue in this case is that it angered many Americans that someone who was partly responsible for a major terrorist attack and the death of many Americans deserved the possibility to escape the repercussions of their actions. However, it would be going back on the opinion of our founding fathers to deny someone the fair chance every American is entitled to.